You know, a beautiful sunset view. That's the dream for a lot of people, right? But what happens when your neighbor's dream renovation completely blocks yours? Today, we're going to unpack what started as a simple neighborhood disagreement in Arizona that just spiraled into a full-blown legal battle, with a twist that I promise you probably won't see coming.
I mean, listen to that. I will never be able to see the sunset again. That one sentence from homeowner Deanna Morris really gets to the heart of this whole thing. This isn't just about rules or building codes. For her, it was about losing a huge part of what made her house a home, something she said was a major reason she even bought the place.
So where are we? We're in the Sundance Residential Community in Buckeye, Arizona. It's one of those planned communities governed by a homeowners association, an HOA. And it was the HOA's own rules that became the battleground for this fight over a sunset.
All right, so let's get our cast of characters straight. On one side, we have the petitioner, that's Deanna Morris, the one who filed the complaint. On the other side is the respondent, the Sundance Residential HOA itself. And kind of caught in the middle of it all is the neighbor, Martha Duran, the one who actually built the gazebo and balcony at the center of this whole dispute.
At the end of the day, this whole story really just boils down to two totally different dreams clashing. You had Mrs. Duran, who wanted to improve her home with a brand new balcony and a gazebo, but for Mrs. Morris, that improvement came at a huge cost: the permanent loss of her incredible unobstructed view of the Arizona sunset.
So Miss Morris, feeling like she was being completely ignored, decided to take things to the next level. She filed a formal petition against her own HOA on January 5, 2015. Let's really break down what she was arguing.
Okay, so Ms. Morris laid out a whole list of complaints. She said the new structures just didn't fit with the vibe of the neighborhood. She argued the construction didn't even follow the plans that got approved and that it wasn't finished on time. She also claimed the HOA totally failed in its duty to protect your property value. And here's the big one. She alleged they used outdated 2011 rules to approve the project instead of the current 2014 rules. That's a huge deal.
And the drama didn't stop with a blocked view. Oh no. Miss Morris also complained about a dozen unapproved lights on her neighbor's new patio and gazebo. She said they were so bright that at night her neighbor's yard looked, and I'm quoting here, like a park when it is lit up. Now, she did admit she never filed a formal complaint about the lights, but said she felt like the HOA would just ignore her anyway.
And then, to pour a little salt in the wound, Miss Morris gets an HOA bill with this mysterious charge on it for over $1,000 in attorney's fees. Now, the HOA later said, oops, that was an administrative error, and they did remove the charge, but only after she filed her petition. You can imagine that probably didn't help the situation.
So, what about the HOA? How did they respond to all this? Well, they didn't just take it lying down. They came to the hearing prepared, with their own witnesses and their own evidence to shut down every single one of Ms. Morris's claims. The HOA came back with a very clear timeline. They showed that the neighbors submitted her plans way back in November 2013. And what's super interesting is that the committee reviewed them and actually denied part of the plan, a whole second-story addition. They only gave the okay for the gazebo and balcony. Then they argued that construction started and finished well within the official 90-day and 6-month time limits. So when you put it all side by side, you can really see the clash here. Miss Morris says the structures violate community standards. The HOA says, nope, both we and the city of Buckeye signed off on the final project. She says the process was flawed. They say, we followed our guidelines to the letter. It's a classic case of he said, she said.
And this one quote from Willard Brunner, a guy on the architectural committee, it just sums up the HOA's entire position. He basically testified that, look, while they think about how a project impacts the community, one neighbor being unhappy doesn't give them veto power over a project that follows all the rules.
This all builds up to the big day, June 10, 2015. You have a judge who has to weigh the very emotional story of a homeowner against the carefully documented process of an HOA. So what happened? Okay, before we get to the verdict, we got to talk about a key legal idea called preponderance of the evidence. It's not like in the movies with beyond a reasonable doubt. It just means Mrs. Morris had to convince the judge that her story was more likely true than not. Think of it like a scale. She just needed to tip it ever so slightly in her favor, even just 51%. So what tipped that scale? Well, according to the judge's final decision, one of the biggest factors was the testimony from the HOA's people, the community manager, and the committee member. The judge specifically wrote that he found their testimony to be credible. That's a powerful word in a courtroom.
And the final ruling? Wow, it was blunt and it was clear. The judge decided that Ms. Morris had failed to prove by a preponderance of the evidence that Sundance violated its governing documents. In other words, she didn't manage to tip that scale.
So what did that mean? Well, case dismissed. Her petition was thrown out. The HOA was officially declared the winner. It really seemed like Ms. Morris's long fight to save her sunset view was once and for all over.
But you know how these things go. In the legal world, sometimes the end isn't actually the end. Just when it looked like the book was totally closed on this case, a wild new chapter was about to be written.
I mean, the judge made a ruling, the HOA won, everything's all settled and done with, right? Well, not so fast.
Get this. 4 months after that big decision, on October 29, 2015, a brand new, totally unexpected document gets filed in the case, and it breathes new life into this whole fight.
This new order used some really heavy-duty legal words. It wasn't an appeal or anything like that. It issued an order vacating hearing and declared that it was remanding this matter. So what on earth does that even mean?
Okay, let's translate that from legalese to plain English. It means the first hearing and the decision were basically wiped off the books. Poof, gone, voided. And remanding means the case got kicked back to the department to deal with again. The bottom line is, the HOA's big victory was erased. The fight for the sunset view was suddenly back on.
This whole saga just leaves us with a fascinating question, doesn't it? We'd like to think that when a judge makes a decision, that's it. It's the final word. But this case proves that the legal process can take some crazy turns, and that even a clear-cut victory can just disappear. It really makes you wonder, when it comes to the law, is anything ever truly settled for good?